The U.S. Supreme Court was scheduled to use a bankruptcy case for making a major pronouncement on federal law. The case was called Rodriguez versus FDIC, and the Supreme Court granted certiorari in late June to decide the circumstances under which federal courts, if they ever can, are entitled to create federal common law in derogation of state law. In particular, this case, the Rodriguez case, raised the question of who owns a tax refund among a family of related companies. Well, there is federal common law called the Bob Richards Rule, which makes a presumption that the entity that incurred the losses gets the tax refund, but in many instances, state law would give you a different result. I am sad to report, however, that it appears to me as though, after oral argument in the Supreme Court on December 3, that the Supreme Court is not going to reach that question, at least not now. It came out very clearly in oral argument that the Tenth Circuit did not base its ruling on federal common law. Rather, the Tenth Circuit appears to have reached its decision based entirely upon Colorado law. And as we know, the U.S. Supreme Court is not in the business of deciding whether or not a lower federal court made a proper application of state law. So it's my guess that the Supreme Court is likely to dismiss this petition as having been improvidently granted. And when that happens, at least theoretically, the 3-4 split among the circuits will continue to exist. However, any circuit that continues to follow federal common law in Bob Richards is doing so at its own peril, because several of the justices at oral argument on December 3rd were, shall we say, not persuaded that there is any valid federal common law in this area. You can read about this decision in my column, Rochelle's Daily Wire, published on the ABI website on December 5. And of course, you can read the transcript for yourself from the Supreme Court. And in addition, on the Supreme Court site, there is a link where you can listen to the oral argument itself. Meanwhile, sit back, relax, and a few weeks from now, we will find out whether or not we have a decision or whether the Supreme Court dismisses the petition as having been improvidently granted. I am Bill Rochelle, Editor-at-Large for American Bankruptcy Institute. I will be back sometime next week with something interesting that's happened in the world of bankruptcy law. Until then, good day.